Welcome to High Stakes Criminal Defense Podcast.
Welcome to the High Stakes Criminal Defense Podcast with experienced attorney Jeremy Babich at Levine Flier and Flier in California. I am your host, Leanne Lyon. When freedom, reputation, and a lifetime of hard work are on the line, the person you choose to stand beside you in court is the most important decision you will ever make. Jeremy is a zealous advocate who specializes in high exposure litigation, from complex white collar offenses to serious felony charges like murder and sex crimes. Known for his trial ready strategy and his ability to navigate the most daunting legal battles, Jeremy joins us to pull back the curtain on what it truly takes to defend a high profile case when the stakes couldn't be higher. Hello, Jeremy.
Hi.
Jeremy, since this is your first show, why don't you tell us a little bit about what interested you in joining and starting this particular area of law?
Well, honestly, for me, to be quite frank, I had no idea in law school what I specifically wanted to do. I kind of had an inkling that I wanted to go into entertainment law, but I also knew that I wanted to try out several fields and internships while I was in law school. And very fortunately, my last summer before my 3L year, my last year of law school, I got an internship position here at Levine Flier and Flier. And during that summer, I got exposed to fascinating cases, fascinating trials, fascinating facts, fascinating ability for me to actually learn. And what I really discovered, and ultimately was something that truly invigorated me, was not sitting behind a desk all day. I figured out that that is not something I want to do. And in this field of law, it's something that I rarely do. I do it quite a bit, but I'm in the courtroom almost every day. And I love being in court. That is where I shine. That is where my passion is at its highest. And I love being a zealous advocate. And I really ultimately saw that this field of law is where you truly can make a huge difference in a person's life. From the beginning to the end of it, people are at their lowest of lows at some points. And this field is where I get people at their lowest of lows in many facets and many aspects. And being a zealous advocate is something I truly cherish, and I wouldn't change it for the world.
So let's jump into this. Jeremy, what happens when somebody is sitting in a jail cell for the first time, facing felony charges, and they're thinking, what's next? What is the single biggest mistake that they make before they even get a chance to call you?
That is ultimately something that I deal with quite a bit, unfortunately, is this big mistake that many people unfortunately do make, is that they speak to the police or law enforcement prior to attaining legal counsel or having legal counsel present before they answer any questions. And that ultimately ends up being something that is very, very difficult to come back from, especially in this field, depending on the facts, depending on the type of case. But ultimately, the biggest mistake, if I was to give one, is speaking to law enforcement prior to speaking to your own legal counsel.
So, as of 2026, what determines whether a person gets to go home to their family after an arrest or is held until their first appearance? Has the process for setting bail in California changed recently?
So, I mean, it has recently. Right now, the main thing that courts look at is no longer the wealth that a defendant has. It is the risk that the defendant poses to public safety, as well as their flight risk, which means how likely are they to make their appearances or whether they would skip and not show up to their trial. But ultimately, that is what the court looks at, especially considering the seriousness of the offenses or the charges that a certain defendant is charged with. That is something that the court will take into high account and determine whether or not the defendant poses a flight risk or if the charges aren't as serious. And the court will also look at the defendant's prior history, whether this is something that they have dealt with prior or they've been a flight risk before, whether they in history have evaded appearing in court or have had issues making appearances. That is something the court will consider as well. So recently, the court has developed what is a zero bail policy where the court will ultimately look, depending on the type of case and charges, the court will look at whether or not the defendant poses a public safety risk and a flight risk, but also it will look at the facts of the case and also determine whether or not, because the court doesn't want to set bail at a price that is unreasonably high, to especially for indigent defendants who can't afford to make bail. So that is something that the court also takes into account. And in terms of setting bail, is making the bail something that the defendant can afford if it does impose a safety or a flight risk.
So you often represent first-time offenders who I have to imagine are absolutely terrified. How do you use a client's clean record and reputation to convince a prosecutor that one mistake shouldn't define their entire life?
That is a very interesting question. And also, of course, depends on the type of charge. So, this system, in my belief, shouldn't be one that is merely punitive. It should also be one that is rehabilitative and also gives defendants a second chance at life. So, people make mistakes. We're all flawed. However, a defendant, and it is my responsibility to show a prosecutor that a defendant, you know what, even if he is guilty of this, but is also someone who has had a great life prior to this, has led a very productive life, been a valuable member of their communities, and show that to the prosecutor in terms of trying to figure out a resolution that is not only fair, but also just, and also one that will be able to look towards the defendant and leading a productive and very fruitful life going forward, and also avoid recidivism so that the defendant isn't just stuck in an ongoing cycle of getting in trouble, getting out, getting back into trouble, and repeat. So that is something that is important where you're showing a defendant this isn't who he is, that he had a momentary lapse in judgment, or that he's completely innocent of something, and kind of goes to show that maybe he was overcharged, which happens very frequently. That maybe he is guilty of something, but not specifically what he was charged with.
So we see it on TV, but in real cases, if the officer doesn't review your rights immediately during the arrest, does that actually mean that the case gets just thrown out?
Honestly, that would be fantastic because it would make my job a lot easier, but unfortunately, that is not typically the case. Based on the letter of the law, the officer is only required to read you your rights when he is about to conduct a custodial interrogation. So when you are being arrested, the officer typically should, out of an abundance of caution, but is not technically legally required to do so. So as a result, the officer, and ultimately you think about it, it doesn't necessarily determine whether or not the case will proceed because there could be other facts outside of your statement or anything you tell to the police officer that would determine your guilt or innocence. In the totality of the circumstances, and the fact that you were not read your rights before you spoke to an officer can lead to those statements being suppressed in the course of your trial. However, it does not ultimately lead to your case just being thrown out because there could be other facts that lead to your guilt or innocence that the DA may decide to proceed on charging you with. However, also, when you are thinking about it, an officer didn't read you your rights, but also the DA may still use those statements if you are put on the stand in your trial as impeachment. Even though your rights weren't read, the DA can still use your statements against you if you do testify as impeachment.
So, for serious felony charges, why is the preliminary hearing perhaps the most critical moment for the defense to test the strength of the state's evidence?
Ultimately, it also very much depends on the case, but a preliminary hearing is a very, very valuable asset for a defense attorney, especially in sex crimes cases. Because if the DA, who also is very much interested in putting the alleged victim on the stand to see how they would do in terms of cross-examination and everything to determine whether or not this is a strong enough case to proceed in. The defense counsel, me specifically, gets a chance to cross-examine that alleged victim without a jury being present, which means you're able to ask a lot of questions, which then give you a basis and a grounding to use at a trial should the case proceed to trial. And using those statements, if the alleged victim gets on the stand in trial and makes a statement that contradicts something she said at a preliminary hearing, that is a very useful tool in showing the jury that that alleged victim lied in that instance. So it's very, very reasonable for them to use that lie in disbelieving any of her testimony at trial. So that is why it is a very valuable tool. In addition, a lot of, or some counties have a policy where they don't even put the alleged victim on, and they will do what is called Prop 115, where they put a police officer on the stand to testify to the facts that the alleged victim reported to them, which ultimately is a crutch for the defense team because you can't really use those statements against the alleged victim during the trial because that's just what the officer is saying is just what the alleged victim reported to them originally in a police report.
Now, sometimes the people who are you're defending have a license. How do you help a professional like a teacher, nurse, maybe a CDL holder manage a felony charge so that it doesn't automatically end their career?
That is something that I come across with very frequently, and teachers specifically, as well as people in the medical field. However, what is important to me, because several teachers are also accused of alleged sex crimes with students, is meeting with the client originally and kind of breaking down the potential avenues and getting from their perspective what is most important to them, whether that being not a resolution where they are not required to list themselves as a sex registrant, or whether that is avoiding any jail time, or whether that is protecting their license because they still want to continue teaching or working in the medical field. A lot of the times, certain professionals, after certain allegations are made towards them, have no longer have an interest in continuing working in that field. However, teachers specifically, I try to make sure that I reach a just resolution for them where, for example, we can agree to a diversionary sentence in which the case is ultimately dismissed if they succeed in completing certain number of classes that the judge orders them to do or a certain number of community service or community labor hours, but ultimately that offense is never seen on the record and they're able to continue their career in whichever field they are currently in.
So I'm sure you handle many cases involving a single lapse of judgment or in an maybe an outburst. How do you build a defense when the facts are messy, but there was no actual criminal intent?
So it actually depends on the crime because some crimes that you're charged with don't necessarily require you to have the criminal intent and you can still be found guilty of them. However, if there are crimes that do require that and there was no criminal intent, that's where my job kicks into high gear in being a zealous advocate to try to persuade the district attorney or city attorney in certain instances, if it's a misdemeanor, that there is no criminal intent here and they're overcharging it, or there might have been an intent for a different type of crime, but it's not shown here. And it's my job to convince that prosecutor to really look at the facts and really, from top to bottom, go through the case to make sure that they aren't missing anything, that maybe they have the wrong person, that maybe, you know what, this wasn't a crime. And ultimately convince them that there is a just resolution where both parties are satisfied and can move forward with protecting society, but also protecting my defendant's rights. Because that's ultimately what the system is here for, is to make sure someone like me is there to protect their rights, especially if they are charged with something they had no criminal intent to do.
So, how does your experience and reputation with the local prosecutors help you negotiate for a diversion or a reduced charge that keeps a felony conviction off of someone's record?
So it goes both ways. In felony cases, what you can sometimes do is apply for a mental health diversion where your client is evaluated by a forensic psychologist, and afterwards you present your mental diversion motion attached with the report of that forensic psychologist to show that, you know what, even if he is guilty of this crime, mental health diversion is the way for this defendant to reach a just resolution where they are able to show that they didn't have the criminal intent, but they had a mental lapse in judgment or a mental attack that they had no idea they were even prone to previously. Where in so many cases, people have a mental breakdown or lose their mentality in certain situations where they are put in a position that they act out of character, and also leads them to believe that they have a high ability to rehabilitate themselves moving forward. And as long as they get the proper tools and resources to do so. But when you are negotiating with that prosecutor and you are seeking that diversionary sentence in a misdemeanor, you want to bring up the past of your client to make sure that they are shown in the light that is more reflective of who they are versus what the facts may portray them to be to the prosecutor. We're all human, and the prosecutor has a job to do. I have a job to do. And my job is to convince them, when the facts and the circumstances call for it, that a diversionary sentence is the most just resolution, especially when someone is a first-time offender and someone who has a previous history of being a valuable member to the community. But that's something that falls on my shoulders to do so.
Well, as we wrap up for today, when a client is overwhelmed and scared, what is the first thing you say to them to help them move from a state of panic to a state of focus in their defense?
That's a very interesting question, which ultimately, unfortunately, happens quite a bit because people, especially clients I deal with, in many instances, are in a situation they've never been in before, ever in their life. So that's something for them that is such a novel, visceral, emotional reaction that I have to ultimately play the role of a therapist in some instances where I do let them get their feelings out. And thankfully, we have attorney-client privilege where I can speak to them privately, let them air whatever they are feeling out, but ultimately convince them and reassure them that I'm here for them. I'm here to advocate for them, even if no one outside believes in them or the public at large doesn't believe in them, or they believe that they are in a position where they are guilty until they prove themselves innocent. It is my job to convince them and reassure them that that's not the case, that I'm here for them, I'm going to fight for them, and that's what I will always do as a zealous advocate, because each client, according to our system, which I believe is the best system in the world, is due a zealous criminal defense, and they have rights, and it is my job to make sure those rights are not violated and are not put aside, and my job to reassure them in those darkest of moments, because most of my clients are at their lowest points in their life when they are put in this situation, that that is not the end, and we are here to fight, and I will continue to fight for them.
Well, that is it for this first episode of the High Stakes Criminal Defense Podcast. When your future is on the line, the right information is your best defense. If you or a loved one are facing serious allegations in California, visit Levine Flier and Flier.com. And if you found this episode helpful, please like, subscribe, and share it with somebody who needs to hear this information. We'll see you next time. Thank you.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.